Welcome, and to those that don't know, my name is Bernice Williams, and I'm with B. Williams Mobile Notary. Tonight, we're going to be speaking or listening to Attorney Sedric Collins as he speaks to us about wills versus trust. So over the next 45 minutes, I hope that you find this information to be very valuable, informative, and there will be a time for question and answer. So at this time, I ask if yours is not already, that you mute your mic until the end. To give you a little background about Attorney Sedric Collins, he is the founder and principal of Legacy One Law Firm, and he represents individuals and families and businesses in estate planning, entertainment, and intellectual property law matters. In his estate planning practice, Sedric provides high value solutions for family and individuals' wealth preservation, asset protection, and protection planning for those we cherish most, our children. His engagement with clients differ from that which is found at traditional law firms because of his willingness to empower through education as opposed to the mere drafting of documents, which may result in failed plan at death or incapacity. And with that said, I welcome to you and I present to others Attorney Sedric E. Collins.
Thank you so much, Bernice, for that warm introduction. Once again, everyone, I'm Sedric Collins. I'm the founding attorney here at Legacy One Law Firm. So I'd like to first of all thank everyone for taking the time out of their evenings to just listen to some information that I feel and my firm feels very important and such a substantial need for in our community. So we know Bernice started off with talking about wills versus trust, but it's a little bit deeper than that. So really what we're going to focus on is legacy wealth preservation planning, planning for a lifetime of protection, guidance, and love. And it does involve, of course, wills, living trust, and other essential documents. So some opening thoughts. So I'd like to start with a kind of a thought-provoking question. What is your why? Right? What compelled you? What motivated you to say, hey, you know what? Here's a Zoom on a Tuesday night. What's important to you? And so we're going to cover here this evening what some of those important whys are for some of the clients and the members of the community that we serve. Because this planning, it's not all about us. It's bigger than us, right? It's about legacy. It's about the people who we love, who we care for. It's about what we've spent a lifetime, some of us, trying to build. And so we're going to uncover a few of those in our conversation at our presentation tonight. Talk about that why this planning may be important to you as an individual, as a family, as a business owner. So for some of us, our why is about family. It's about those who we leave behind if something happened to us, right? Some of us on this call may be grandparents. Some may be starting new families. And so this planning, once again, it's not about us, because if something happens to us, if the unspeakable happens, then who's going to live on? Who are you going to pass the torch on to? And so we're going to talk a lot this evening about family. For others, it may be comfort. What do I mean by comfort? Making sure that your family is comfortable should something happen to you. Making sure they're just not emotionally comforted, but also comforted from a financial standpoint. For others, their why may be strategies. Well, how do I keep my family out of conflict? How do I keep my family out of probate court? How do I keep my house out of court? How do I make sure that the property that I work for doesn't end up in the wrong hands? For others, there may be taxes. Some of us may have heard of living trust and how there may be some tax planning benefits to that. There is, unfortunately, something called a death tax, right? So the federal government has federal estate taxes. But thankfully for California, which is where we're based, my law firm is based, California does not have a death tax. I like to say they tax us enough while we're alive, right? They're going to give us a break when we die. But the federal government does have an estate tax. And we'll talk about tonight, we'll just touch on it very briefly, how that might impact you and your loved ones. For others, their why may be assets. These are the things that I've spent a lifetime building. Some of us are homeowners. We have retirement. Some of us may just have life insurance policies. We're all at different places financially, but what you have and what you accumulated is yours. It's yours. No matter how small or how substantial your assets may be, they're yours. So your why may be, well, what's going to happen to my assets? What's going to happen to the things that I've worked for, not just at death, but also should I become incapacitated? So we'll touch on that tonight. For others, it might be self-care, right? Your body, your choices should be honored, right? And we're going beyond just burial or cremation, but what about your healthcare decisions? Who will speak for you if you cannot speak for yourself? Who will be able to articulate your wishes with regard to your healthcare or financial decisions if you become incapacitated? So planning the why may sometimes be about your own self-care, your body, and making sure your wishes are honored and respected. So our top four: your choices and wishes honored, total assurance that what you've worked for is going to end up in the right hands, which then will equal peace of mind to you and to those you leave behind. And I'll stop on peace of mind really quickly, because a lot of times when we think of peace of mind with this type of planning, it's not just our peace of mind while we're alive, because someone might have to clean up a mess when you're gone. Someone may have to wrap up final affairs for you, even if you're incapacitated. So it can be for the peace of mind for your heirs, for those who you leave behind, knowing that business was taken care of while you were here. And then finally, all that means comfort, right? It means comfort for you now in certain situations, and it also means comfort for future generations. So some of us on the call have already embarked on this journey of estate planning. Some people on this call or this Zoom that may already have a will. Some people may already have a living trust. But something I want to share with you, one of the number one ways that estate plans fail is because they're outdated. They're outdated. They're just old. So I recall a quick story. I've come from a higher education background, and one of the professors who I worked with, when she found out that I was opening my own law firm, she said, "Sedric, let me tell you something. You know, my daughter's 27 years old now. Her father and I, we created a living trust when she's 7. She was 7 years old at the time. We haven't touched it since." And she gave me a great piece of advice: find a way to keep in contact with the people you serve. She never heard from her attorney again. And what has changed over 20 years or over 10 years? Laws change, your family dynamics change, people pass away, you get more assets, you get divorced. So deaths occur in the family. So many things change. So that's one of the reasons we call it a living trust, right? Because it should grow and it should evolve as your life grows, changes, and evolves. So a trust or a will is not something that just sits static, but it should be reviewed. Now, others may be on the call tonight saying, well, I don't even have a plan. I don't have a plan at all. I'm here to share with you tonight that if you do not have a plan, the state of California has a plan for you, but you may not necessarily like what it is. So what is comprehensive planning? Because that's thrown around a lot. When you hear the term a comprehensive estate plan, right? It's not just about documents. Yes. So there are several documents that make up a comprehensive plan: a will, a living trust, your advanced healthcare directives, powers of attorneys, guardianship nominations for kids, right? Those are some of the documents that comprise, but it's much more than that. Comprehensive planning is goal-oriented and solution-oriented, not just focused on documents. It's holistic and integrated, not partial or piecemeal. It'll take into consideration your short-term, immediate, and your long-term goals. It's proactive and customized to your goals. Now I want to stop there for a minute. Proactive and customized means it's not cookie cutter, right? It's not a form template you pull off the internet and plug some details in, right? We've all seen those online. You have a unique family dynamic that's much more than just a set of documents or a template. Having a trusted advisor, not just a technical advisor, planning that's focused on achieving your goals and your vision for your life. So let's look at holistic planning. Now, most of us on here, I like to share this Venn diagram because we all know about the financial and retirement planning. We're at different stages on the financial spectrum. Some of us are just beginning to plan for retirement, while others may already be in retirement on this call and may have spent your lifetime building wealth or building whatever your version of wealth and prosperity is at this time, but you've worked for that. And a lot of emphasis was placed on that. But then sometimes what's often forgotten, or often, is estate planning. In fact, 60% of Americans does not have any estate plan in place at all. 60%, the number is staggering. So why is it often overlooked and forgotten? It's a taboo subject, right? No one wants to talk about their own mortality, but we all know we're going to leave here at some point. We know it's not necessarily the attractive or the compelling conversation at the dinner table, at the dinner party, but no one would disagree that it's not the responsible conversation to have, because there's an actual intersection between your financial and your retirement planning and your estate planning. One is your wealth building. One is your wealth preservation. That's going to be passed down to the future generations. That's where estate planning and your retirement and your financial planning, they intersect. What's going to happen to that 401k if something happens to you? What's going to happen to that house? There's two typical schools of thought when you talk about estate planning. You got your run-of-the-mill, we call it planning for death. Then you have your planning for life. Now, here's your typical planning for death experience. It's a one-time transaction. There's a bunch of documents you're going to sign. It may or it may not avoid probate. That plan may or may not avoid estate taxes. It leaves your assets to heirs outright and unprotected. Here's a big one. There's no ongoing legal guidance. And here's the thing. If it potentially subjects your property and your assets to loss to the California State Department of Unclaimed Property. Here's a very interesting statistic that I'm going to share with the group tonight. Right now, you can Google this, you can look this up. There's over $9.5 billion with a B in the California State Department of Unclaimed Property. And the lion's share of that is because people failed to plan. Their heirs don't know the bank accounts they have. The kids don't know about the retirement plans and policies. Stuff gets overlooked and forgotten. And by California law, if the heirs cannot be found or that property is not claimed, it's legally and rightfully but passes to the state of California. So what about planning for life? What's on the other side of the spectrum? Well, it's an entirely different experience. It's one where you make informed or empowered decisions. It saves your family thousands of dollars. Your assets are not lost to the state at your death. It can protect your family from creditors, predators, bankruptcy, and divorce if set up the right way. It looks like a lifetime of the right legal and financial choices. And most importantly, it may keep your family out of court and the big one, out of conflict. Are your kids going to fight? Or your siblings? Some of you are in sibling rivalries maybe right now because someone has passed away. And mama left this to me, well, daddy left this to me. If we're not going through this right now, we've all heard stories of that. And primarily, it's of importance with this type of planning. It can keep your family out of court. and from conflict. And most importantly, your plan will work when your family needs it. So planning for life from a financial standpoint here. So here's kind of a laundry list of what we've all heard of these. Some of us have retirement plans. We have investment planning. There's education planning for our kids to go to college if you're at that stage of parenthood. There's personal risk and life insurance and things of that nature, right? Some of us are business owners on this call. So here's a kind of a pyramid. I like to call it my legacy pyramid here, because it begins at the bottom of this pyramid with money management and the different things that involve managing your money. You go up the pyramid a little bit higher, then we all have goals for what we want to do with the things that we've earned. There's retirement goals. There's education. What about healthcare? Your estate, charity, right? Who do we want to give to? Are we active members in our church community? Are we? Do we want to give to other social funds or projects that we're passionate about? This all gives us financial confidence. Things are organized and in control. We're taking care of our loved ones. As we get higher up the pyramid, it equals more time, less worry. With the ultimate goal of fulfillment of our life's purpose. And here's how we come in with your life's legacy. Every day that you wake up in the morning and your feet touch the floor, you're writing your legacy. So what will your legacy and what will your story be? So I shared earlier that if you don't have a plan, the state of California has a plan for you. Some of us have heard of the guardianship or the probate court process. Now, here's what probate is. I got a kind of a core definition here at the bottom. It's a lawsuit that you file against yourself with your own money for the benefit of your creditors. Probate court in a nutshell. What probate is, it's litigation that's opened up against your estate once you have passed away. And yes, it is first of all for the benefit of your creditors. And oftentimes the court is the very first creditor in that process, because the court's going to take theirs right off the top. And we can explain in further detail how that works. But then what's left over? And this is why I have this water faucet here. So I want you to visualize at the other end of this faucet, it's your kids, it's your grandkids, your friends or family, whoever you're leaving stuff to, they have a glass out, they have their cup, right? And they're waiting for that outpour of what you've left. But this is what's going on behind the curtain, behind the scenes with the legal process that takes place after we pass away. Someone's going to have to petition the court in your family for a probate proceeding. You may or you may not have a will. And in this case, let's say you don't have a will. So now the court is going to have full reign over what happens to your affairs under California law. And so you're going to have to hire an attorney, because you're not allowed to represent yourself solely. Because why? You can't represent yourself for one, because you've passed away. So there has to be one and a representative of the estate. And also there needs to be an attorney to represent your family's estate. And so that starts here at the top of the pipe here. The first clog in the pipe is we have attorney's fees. Attorneys aren't going to do this out of the kindness of their heart, right? So something happens to you, someone from your family, whether you have a will or not, is going to have to hire someone, take time off work, and get involved in the court process. Then there can be further down the line, there's appraiser fees. What are these appraiser fees? Well, you have a home, maybe. Maybe you have bank accounts, you have personal property, you have jewelry, you have furnishings, car, all of this stuff. The court's going to want to know, hey, what does this person have? We need an inventory list. Give us a value. There's also executor fees. If you don't have a family member that can step in, that's responsible, that can be bonded by the court, then the court can charge executor fees, because they're going to appoint an individual who they choose to oversee your affairs and to work together with the court to make sure that your affairs are wrapped up. So there's more fees here, executor fees. Don't forget about filing fees, right? If anyone's been to court, they charge you when you initiate a lawsuit. Then there's the bond premiums. What's that? Like, you thinking bond, did someone go to jail, right? No one went to jail here. What happened is once you have an executor that steps forward, that person who is the person who's overseeing your estate has to be one of sound moral character and judgment. And so the court will oftentimes, if there's no will in place, they'll require that relative or that friend who steps up to get a bond. Why? Because they want to make sure this person doesn't run off to Jamaica with your stuff, right? They want to make sure that, there's going to be no misappropriation, no thievery. They want to make sure your estate's going to remain intact. And if not, it's insurable with a bond. And then finally, as we get closer to the spigot, there's creditors. Yes, those two, right? Why creditors? Because probate is, first of all, a public proceeding. It's not private. It's public. So the court will give, it's kind of like a speak now or forever hold your peace period. They'll give a limited period of time where your creditors can make claims against your estate. Now, all of this stuff is happening before any one of your children, friends, loved ones, or organizations that you care about receive a dime. So when all of that, after all of this, these fees and processes take place, and in California, probate can be anywhere from 6 to 24 months. And these were actually pre-pandemic numbers, 6 to 24 months. At the end of that process, whatever's left goes to the people that you love.
Excuse me.
Go ahead.
I'm sorry. Going back to what you were talking, if you can go back to that previous slide.
I don't think I can go back, but
okay.
Go
the
ahead.
one that, okay, on that previous slide, does that still happen even if you have a will?
Great question, Bernice. Yes. There's an old saying, where there's a will, there's a probate. Here's why. Because the California court must make sure that your will is valid under California law. There are certain requirements to legally prepare a will, and that your will is going to go before a probate judge who's going to determine whether or not your will has been validly prepared in accordance with California law. So in essence, when you plan with only a will, you're actually signing up for the probate process. So absolutely, if you have a will alone, you're going to end up in court. That's the court's system for distributing your assets. Absolutely. Good question. So this screen, it's one of my favorite and most heart-wrenching screens to share. Why? Because I grew up listening to Aretha, who didn't, right? Marvin Gaye, Barry White, Prince. So these icons who helped shape our worlds from an artistic standpoint, they were in the news not only for their death, but they were in the news for the fact that they didn't have a will. In fact, I just read an article today. I don't know if you guys read this, but Prince, his estate is finally, after 5 years, wrapping up. After 5 years. So one of the things that's unique about these individuals here is that they just happen to be famous, but they're still in that 60% of Americans that did not have a will. And so seeing some of these deaths, seeing that I do represent entertainment clients as well, this is one of the things that motivated me to find Legacy One Law Firm, because I said, if we have these people of affluence and influence that don't have a plan in place, or how much more my neighbor, how much more my colleague, my friends, the people in my immediate sphere of influence, what's going on with them? So many of us are on this call because we have beneficiaries. We have people we care about, people that we love, right? If you have planning with simply a will, which is sometimes the most popular, because we all know about wills, because wills are romanticized in movies. We hear about them. We see last will and testament, right? But we have these beneficiaries or these heirs. Now, planning with a will has some pitfalls, because one thing is that your beneficiaries can receive assets outright and unprotected. What does that mean? That means that if you have a $500,000 life insurance policy and your son or daughter or combination, they've turned 18, are they going out and buying that Porsche? Why? They just got $500,000 from grandparents, $300,000 from a life insurance policy from mom and dad. So one of the shortfalls about planning with only a will is that what happens to that money? Will it be squandered? Are your children even old enough? Because there's something called, I'll get into in just a second, the Uniform Transfer of the Minors Act, and that kind of takes me right into this screen. Your kids could be at risk even if you have a will. I'm reminded of a quick story of a colleague who had a friend who passed away when she was 8 years old. Responsible mom, who was a single mom, who had a life insurance policy that she'd set up for her son. Well, there was a reason why she was a single mom, because unfortunately there was a deadbeat dad involved who wasn't involved in the child's life, but just popped up every once in a while. But unfortunately and tragically, the mom died while she was washing dishes in the kitchen of a blood clot. Fortunately for her son, she did have a life insurance policy and a simple will. However, unfortunately, he was only 8, 9 years old. And the deadbeat dad got legal custody of his son. And we can all pretty much guess what happens from here. The life insurance policy that was left in the will went to the deadbeat dad, who was then charged with the care and custody of his son. The money, needless to say, was blown in 3 to 4 years. So that money that she had hopes for in terms of maybe paying for his college education, helping him buy his first home, that money was squandered. So that's just one example of how our kids can still be at risk, even if you plan with a will, because why? A will is just a distribution of your assets, not the maintenance. There's no control beyond the grave. There's no control beyond the will. So planning for your assets, that's inheritance-based. That's based upon, okay, long-term focused, right? There are several different strategies that go into this type of planning. You have non-retirement assets, which can receive a step up in cost basis. Now, that's fancy terms for your house and saving property on saving money on property gains, taxable gains, okay, from property. So that's one benefit of this type of planning that we can get into in a little bit more detail, perhaps in the one-on-one call. But there's also tax-free insurance benefits with life insurance planning. Some of my clients use their life insurance proceeds to not only pay for college education, but to pay off their mortgages should they pass away untimely. And then there's also various tax reduction strategies that can be discussed. And you can have your estate set up in such a way that's going to help mitigate your tax liability should something happen to you. So turn your wishes into directives. We're seeing a situation right here on the screen. Well, someone's on life support. Perhaps they're incapacitated here. Will your healthcare directives work when you need it? Because this isn't all about death. Like I said, this is about life. What if you survive the encounter? Now what happens? If you say, okay, well, my wife or my significant other, my husband will make decisions. Well, what if the two of you are incapacitated together in a car accident? Now, your spouse or significant other, they can't speak for you. Who's going to make those critical healthcare decisions on your behalf? Your wishes are not in writing. You can't speak. Secondly, who will make financial decisions when you cannot? Who's going to help protect your good credit? Who's going to make sure your bills get paid if you have little ones? Who's going to make sure that the people who you love and care about have access to your resources if you're down? You can't just walk into the bank, right? And the unfortunate part of this is that there's a court process for this called the conservatorship, that if you're in an emergency situation and your family needs access to money, now you have to get the court involved. And when the court gets involved, there's more money involved. So what are some common planning techniques that don't work? I like to call this the bootleg estate planning, right? Like, okay, I don't have a plan, but this is what I have. It's going to put my house in everyone's name. I'm going to just designate beneficiaries on my life insurance policy, and I'm going to just sign this will. Everything's taken care of. Well, there's problems with all three of these planning strategies. One, if you pass away and your spouse passes away shortly thereafter you, and the houses are in your name, that house is going to end up in court. So though you have your name, your spouse's name, and sometimes kids, here's the thing about beneficiary designation planning, where you just name beneficiaries. Think about this for a minute. The people who you name as beneficiaries, they're people who are very close to you. They're the people you love the most. So it's a good probability that, or just a chance that they may pass away very close to you in an accident, or they may be too young to even manage or handle the money, right, that you're leaving for them. So that's the problems, the issues with just naming beneficiaries or just signing a will. We already talked about a few minutes ago some of the limitations on just planning with a will alone. So what is it? What's the only foolproof way to keep your family out of court when something happens to you? It's a fully funded living trust with disability provisions. So I want you to picture your living trust as a treasure chest, and all of your assets, your retirement accounts, your bank accounts, your house, your stocks, the assignment of your personal property, your life insurance, all of that is going to be channeled into your trust. This is the treasure chest. This is how you're going to pass down your generational wealth. This is when we hear about generational wealth, this is how it's done. It's put into a chest called a trust, a family trust, where there's rules and regulations and guidelines and accountability. And there's no gray area about what mama said, what was mama's wishes, what was daddy's wishes. So how do you fund this trust? Some of you in the call maybe say, hey, Sedric, we don't have much. Well, you don't have to have much. But what you do have, you can make sure is accounted for. Your bank accounts, investment accounts, real estate, life insurance. Some of us are retired and we have 401ks and pensions. And different, if we work for the state, there's 403B plans and 457 plans. If you have property, you can fund it with your trust, whether it's personal property or real property, as in real estate.
Excuse me, Sedric. One more question.
Yes, ma'am.
So when you reference funding your trust with, bank accounts and so on and so forth, but for those that don't have much, and if one is a beneficiary, I know that I'm the beneficiary of my mom's estate and something's going, I know that she's going to be passing soon. Can't I just go and get whatever money's in her account and just take care of her business that way?
Well, it doesn't necessarily work that way. You want to say yes and no if you are if you're named on the account. And a lot of times this happens a lot with our seniors. They're getting tired in their body. Maybe there's some ailments going on. They're not as mobile as they used to. So they put a child that they trust on that bank account. Now, maybe that's great if you're an only child, right? But a lot of times there's other children involved. And so what if mom passes away unexpectedly and now there's one sibling who now has access to everything that mom worked for? And now they take that money and now they go get surgery with it. They get a new house, or they pay off some credit card debt before the other siblings even get involved in the process. This happens more often than you think, because naming beneficiaries on an account is not the same. And from another legal standpoint, the banks do not want to get sued. This is why they turn over the stuff to the probate court and let the court decide. Because what if they gave all that money to the child who came in and said, my mom's passed away, but mother didn't want that. Mother had 3 other kids who she wanted to provide for, right? So the bank and the financial institutions, they don't want to put themselves at risk. They don't want to make that decision. They want to send it to the probate court if it's not set up properly with the banks. A very good question, Bernice. So who else wants to protect their inheritance completely? Do we like the idea of making sure our children, the people that we love, don't lose their inheritance to a lawsuit, to a spouse, a divorce? What about the idea of trusted asset protection that actually works? Now, really briefly, for time's sake, what about estate taxes? Right now, there is a $23 million exemption. So what federal estate taxes are is you have a threshold that if your estate, when you pass away, one of the reasons why the court and the government wants to know what you own is they want to know what they can tax. Now, right now, If you're a husband and wife couple, you have an $11 million exemption apiece, just over $11 million. So we can discuss how you can put that together and have a $23.6 million exemption, meaning if your property doesn't rise to 23 million, right, you're exempt from taxes. Now, I know what's going through everyone's mind right now is that this is rich folks' problems. This doesn't account. That number, that $11 million, it changes. I have colleagues who remember when it was 1 million, 3 million. And in recent years, it was $5 million per person. You can have a house and a life insurance policy in California that can be $3-4 million. So the reason why I'm bringing this up is because just for your education to know that Congress does vote on what's called an estate tax, a federal estate tax, that if you rise above that exemption, you can be looking at 40 plus or in excess of 40% of estate taxes if your property rises above that threshold. And you have to keep your eye on that number, because if it drops down, right now we're in a pandemic. There's a lot of things that money that's being spent on vaccines, a lot of money being spent on stimulus checks. Who will pay all of that back? We will, the taxpayers. And the easiest people to take from are those who have died. So the estate tax is going to drop. All of the financial experts are projecting that Congress is going to vote, and it can be around $3-4 million per individual, which will take that $23 million down to $7-8 million estate. Like I say, with life insurance policies, a home, it's not hard to cross that threshold. But estate planning can address some of those issues that pertain to taxes. So estate tax strategies, just to touch on this, there's gifting strategies, there's various types of trust, there's life insurance policies, and more things that we can discuss for your individual family situation for estate tax strategies. Now, it's not just about your money and your things. What about your values, your stories, your experiences? Here's a question. If you had to choose between the people you love receiving your money or your values, your insights, stories, and life experience, which one would you choose? The former or the latter? Well, the good news is, with the right planning, you can have both. So, to kind of wrap things up, there is no one size fits all type of planning. There's no cookie cutter. Let me pull a document off the internet. We see that all the time. Who do we see that from? The survivors. We see it from the kids. It said, my mom had this will that she pulled off. We have this trust. A lot of times it's just a template, a cookie cutter template. You have a unique family dynamic that we want to capture and we want to protect. And so the way that we do this is through proper holistic plans. They're not just focused on documents. They're designed to keep your family out of court, to make sure assets are accounted for so they don't end up in the Department of Unclaimed Property. And if you have small kids, some of us who have kids under 18, have you named legal guardians for your kids? What would happen if something happened to you? Who would step in to play the role of parent? It's not your godparent. That's not recognized under the law. You have to have the right plan in place to make sure your kids aren't in the custody and care of strangers trying to figure out who's going to step in your shoes. How we do this, how our process starts, is what's called a family wealth planning session. We've been doing this all virtually since the start of the pandemic. I like to say we're pandemic friendly. Most of our planning takes place. If you were able to log into this call tonight, onto this video, you can plan with us. You can do your planning in your pajamas if you like, right? You can do it from the comfort of your own living room. And the planning starts here with our family wealth planning session, where we'll get together, we'll look at your unique family dynamic, we'll look at your assets, and we'll discuss what happens based upon your current plan right now under California law. And we can put together an outcome, a strategy that's documented, that will execute your wishes, helping you to make more informed and empowered choices. So that way, you know, with certainty, and you receive that expert guidance throughout the planning process. So it all starts with our family wealth planning session. So with that being said, I'd be remiss if I didn't leave you with the opportunity to make your appointment for our family wealth planning session. Some of you today have been putting this off, and that's why you got on the call. You've been like, I've been thinking about doing this every year around January for the last 10 years. I know because I hear this from my clients who finally do it and they got the monkey off their back, so to speak. And now they can rest assured that they're taken care of. So to help everyone on this video call tonight make the first step, we have two gifts. One, it's a certificate for a legacy wealth planning session. That's the family wealth planning session that I just spoke about. It's a $750 value. We're going to make a way. There's going to be a link that Bernice is going to put up, and you're going to be able to click on that link and get on my calendar. And we're going to discuss in detail what that legacy wealth planning session looks like. And we're going to waive that planning session fee so you don't have to pay for the time just to have the discussion, which so many law firms will charge you. And gift number two, for those who really want to be proactive and they sign up tonight, we'll have a gift certificate that will be used and applicable toward either a trust plan or a wealth plan. So it's a $250 gift certificate that can be used toward either our trust planning package or our wealth planning package. Now, gift number one, just for being on this call, if you set an appointment with us next week, or if you click on the link sometime in the future, you reference this video tonight, we'll honor that. But gift number two, if you want to receive gift number one and gift number two from our law firm, then those who sign up in the link that Bernice is going to put in the chat, they're going to take advantage of $1,000 in savings to get started with this planning for their loved ones. So at this point in time, we're going to open up the floor for any questions. Thank you so much for your patience and for listening. What questions are burning in your heart tonight?
I have a question. Uh-oh.
Hello?
Hi.
Okay, I'm sorry. Your mic was muted or something was happening.
All right. Can you hear me now at this point?
Yes, I can hear you. This is
okay. Great. This is Linda Kerr-Bradshaw. I have a question. So I have a retirement fund. I actually have two. I have a retirement fund that I rolled into my investment account with Fidelity, but I also have a living trust, and I did not put the investment account in the trust. It has beneficiaries, of course. So I'm not sure if I should actually place that in my trust, the actual retirement fund. And I'm currently working for another state agency where I have another retirement fund that's coming. I've not retired as yet. So I'm not sure if I should actually roll it over or just leave it where it is as a separate investment account or pull it from there. I don't know, because I rolled it over from a company that I worked for years. And so I'm not really sure if I should do that or not.
Okay. Now, first of all, thank you for asking that question, Linda. I can't offer you financial planning advice. If you do have a financial advisor, you do want to check with that financial advisor. But one of the things that we do with passing that down to the next generation, you want to make sure your beneficiary designations are correct on those 401ks, because your retirement accounts are classified as what's called beneficiary designated assets. You said that you named the beneficiaries, but you have a trust. So what happens if your beneficiaries pass away? Now, if you are married, then it's designs that your surviving spouse is your primary beneficiary. Okay. But in most cases, you want to seek the advice of, I don't know if you have an attorney that you've been working with now, because I can't give you individual legal advice. You're not my client. But what you want to do is you want to make sure that you have the proper beneficiary designation. So that way, if your primary beneficiary dies, your trust, your 401k does not end up in probate court. So that's why this is very important to have this conversation with your attorney, if you have one, and with your financial planner to make sure that your beneficiary designations are correct in order to avoid probate.
So I want to make sure I understand. So basically, you're saying because they're beneficiary designations and they're not listed in my trust currently, that could be a problem with probate.
Well, it's not listed in your trust. It's it's the beneficiary you name. Your trust can be your beneficiary.
Right.
Your trust should be not your primary beneficiary on your life and your 401k, but your contingent beneficiary. So if your contingent beneficiary. So what we can do is, if you want to schedule a call with me as well, I'm more than happy to have a conversation. I don't know if you have an attorney, but you want to make sure your beneficiary designations are correct. So that way, that's how it's not what's necessarily in your trust. It's how you've taken title to assets, and whether you have your trust as a beneficiary on certain policies. That's how the financial institution knows if you die, it's going to your trust, or if you die, it's going to your surviving spouse. You see, so you have to plan for both. If you have a surviving spouse, yes, your surviving spouse is first in line. But what happens if you and your spouse pass away?
Got you. Yeah. Okay. That was my question. Thank you. I'll schedule some time.
Absolutely. Thank you for the question, Linda.
Sure.
I have a question.
That's Sharon?
Karen, yes. Once you establish your trust or whatever you're going to do, and you need to make changes, say a year later, you had a addition to the family or income or what have you, is there a fee to make a change to your trust?
Okay, so great question, Sharon. You do want to make periodic updates to your trust, so that way your trust is not stagnated, right? It's not stale, so to speak. So one of the things that you can do, it depends on who you hire to do your trust. Your trust should be flexible enough so that you're not calling your lawyer every year trying to have adjustments made. In fact, once you acquire new assets, you don't even need to touch your trust, because the secret sauce with this, it's how you take assets, how you take title to assets after your trust is created. Here's a brief analogy. If you started a business tomorrow, it was a corporation. Think about it. You have a company that you started. The company has its own bank account. The company has its own credit. And now your company may have things that it owns separate than you as a person. Your trust is the same way. It's how you take title to assets. So once your trust is established, if your trust does not need to be updated, and if it's drafted the right way, then it should have some durability and some longevity. If you get new assets next year, you should simply take title to that asset in the name of the trust.
Got it.
That's how that works.
Thank you.
You're quite welcome, Sharon.
Also, there is a Juanita Hunt. I think I may be saying her name incorrectly. Yes, Juanita Hunt, are you still here? And if so, you can unmute yourself and ask your question.
Hi, yes, my question was, when you were talking about the 8-year-old young man that his father took it, so their annuities are available. And if annuities are available, what impact does a death have on annuity?
Great question. So Juanita, an annuity is also a beneficiary designated asset, meaning that once the annuitant passes away, you have beneficiaries who are named. And let's say, for example, she had an annuity instead of a life insurance policy. It's the same story. She names her son as the primary beneficiary. It goes through the same court process, right?
Oh, go ahead. I'm sorry.
So the annuity is no different than the life insurance policy. It's very similar in the fact that there's a beneficiary once someone dies. So if the same story, if I take out that, I can replace life insurance with annuity. It's the same exact way. The thing is, you want to make sure that your trust is the beneficiary of that annuity. You have a family trust, so that way, if that mother had the right legal guidance, she would have had a trust established for that annuity or life insurance. They're interchangeable. And that annuity, those funds would have been distributed to that child when he was an adult.
Got it.
Thus avoiding all of that.
Okay.
Does that make sense at all? So it doesn't matter if it's life insurance or annuity, it's just money that's going to be paid out when somebody dies.
Well, with most annuities, you do have to, well, not all most annuities, but some annuities, you'd have to go to court and request funds, correct?
Not if you have a trust.
Got it. Okay. Got it. Thank you.
You're quite welcome.
Andrea is next.
Hi, everyone. I just first of all wanted to say thank you so much for this forum. It was very informative. It's some things that you've already heard before. And like you said, Mr. Collins, some things that need to be put in place that you've been tabling for a while. So I would definitely, I'm going to make an appointment with you, but I also have a village that I want to get something like this to them. So if we could speak offline, possibly as to how I may be able to do another form in this capacity with some close friends and families as well.
Absolutely, Andrea, and you're quite welcome. I'm glad that you were able to receive something from this, and I'd be more than happy. Once you and I talk, we can certainly arrange something offline to where we can get together in a similar setting as this for your tribe, for your village. Absolutely.
And Danielle, Andrea, can you unmute raise your hand? And Danielle Miles is next.
Hey, good evening. I just had a couple questions. Firstly, are you familiar with sovereign individuals or secure party process or creditors? I'm sorry.
Okay, so sovereign individuals, and what was the second part of the question?
Basically, secure party creditors. Same thing.
Okay, so I have some familiarity with that, but I think that's more a specialized. Are you talking about sovereign citizenship and things of that nature?
Yes.
Okay, yeah, so we would probably have to talk offline about that.
Right. I just wanted to make sure you were familiar with it.
Absolutely. I'm definitely familiar with it. But one of the things that I can say and speak to that is that once you set up a trust, no matter what state you're in, your trust is going to be governed by a particular state's laws, right? And so the good news is let's say if you've established some type of independence under this, then yes, you want to avoid the system. Part of this is you don't want to be a part of the system. So the trust, the plan with this is a private agreement where you decide who's going to wrap up your final affairs. However, it could still end up in court if somebody sues you, if there's a fight your trust could still end up in court. And then
that was my second question as far as was it a TOD or a transfer on death? How does that play into just the estate process planning and hold up to probate? Okay,
so great question. I recommend transfer on deaths a lot to my clients who have trust. Because what's going on with transfer on death is you don't have a trust, it's going to a person. What happens if that person dies? What happens if that person is a minor, right?
So the TOD should be inside of the trust.
Inside the trust, exactly. And we show clients how to set that up. Absolutely.
Awesome, thank you.
You're quite welcome.
Okay, I don't see any other hands raised. And there's no other questions that have not been addressed in the chat room. So I also want to be respectful. Somebody else raised it. Sharon Jackson.
Yes.
Question.
Yes. Do you only represent California residents? I'm in Tennessee.
Great question, Sharon. Yeah, unfortunately, I'm only licensed here in California. You know, I serve clients all over the state, but beyond those borders, I do not serve at this time out-of-state residents.
Okay. Thank you.
But hopefully this was helpful. And I do recommend now starting the research process of finding the attorney that's going to align with your family values. And hopefully you're able to take something from this to at least know when you're shopping around for that right attorney, they gotta have to espouse some family values, the values that align with your values. That's the number one piece of advice I can give you with shopping for the right attorney in your state.
Okay, because I definitely learned a lot because I'm in loan signing and some of them are in trust. And I was wondering, I said, okay, why do they have a trust versus a will? So now I know the difference.
Absolutely. I'm glad you shared something.
Thank you.
Thank you, Sharon.
Yes, Sharon's one of my notary buddies, and thank you also for being on here. To be respectful of everyone and their time, again, I'd just like to thank everyone for joining us in our presentation. I've placed the link to have the 20-minute consultation with Mr. Collins in the chat. So feel free to click the link and that'll take you to his calendar, and based on your schedule and his, you can schedule some time to have a follow-up conversation if there's other information you'd like. Also, there's going to be a survey that is emailed to you. We ask if you would please complete it and return it. This is our first one, and I would like to do more, but in order for us to do more, we want to make sure that we are giving you valuable information, and that this your feedback is important. Okay. And anything else you'd like to share, Mr. Collins?
That's it. I'd also like to encourage you just to take the first step, because that's the most important thing, is taking that first step. And there's no charge for that consultation. If you sign up, I'm not going to charge you or bill you for that conversation that we have. So just to get that information, we can discuss the plan that's right for you and your family's situation. So I'd like to encourage you to take that step. We're in listen, there's New Year's resolutions have been out there, right? And so I believe that this call is timely for those of you who have been thinking about doing this, but been putting it off. There's no better time than the present, because that's all we have. That's it.
Excuse me, before we leave, also, I'm sorry, Shantae had one question, or raised her hand.
Yes, good evening. I did want to say this was very helpful. I am a notary also, and I'm a life insurance agent and a couple of other things. And this was very informative for me, as well as I think this was an excellent form for you, especially since Bernice said this was the first time you guys have done this. This was excellent. I will probably take advantage of the time to have a consultation at a later time, but I won't click on the calendar now because I'm not exactly sure when. But I do want to say that this was an excellent form that definitely tons of more people need to find out, because there's a wealth of information. And like you said, even just in regards to the beneficiaries and how they're signed up on their life insurance policies and their annuities, and also their retirement packages and how it's linked, and their bank stuff. It's just a wealth of information that people need to be able to update and find out how to properly do these things, because once someone has passed, that's not the time. And then that's when it starts to become a burden, trying to scramble and get all of this information together.
Absolutely. Thank you so much for that feedback, Shantae. I really appreciate that.
Okay. I'm looking at the chat, and in the chat, everyone is saying thank you. They appreciate the information. This is very helpful. So I thank you. I thank you all for joining us, and we'll keep you posted for the next time we do something like this. Thank you very much, everybody.
Thank you so much for your time. Good night.